Hello and welcome back. GovDoc News. No opinions, just facts and summaries of government documents. You take it from there. Back at it with a Supreme Court order from October 14th, 2025 in the case Lee v. Poudre School District R-1. All right, here we have a denial of certiorari by the Supreme Court. So, let's get into the background of the case. This case involved parents challenging a public school district's policies and practices related to gender identity support for students, claiming these actions violated their constitutional rights as parents. The minor children involved in this case sued through their parents as next friends, basically a legal way for minors to bring claims in court. The case stems from two events at the school district in Rice Elementary School and Wellington Middle School. The first incident occurred in 2022 at Wellington Middle School. A 12-year-old girl was invited by her teacher, Jenna Reap, to what she was told was an after-school art club. In reality, it was a Gender and Sexualities Alliance GSA club meeting. At the meeting, a guest speaker, Kimberly Chambers, a substitute teacher and GSA advisor, discussed gender identity, suggesting that discomfort with one's body might mean the student is transgender. Chambers encouraged students to explore their identities privately and discouraged telling parents if they feared negative reactions. The 12-year-old girl later told her parents she might be transgender, and the parents alleged that the school staff influenced this without their knowledge. The second incident occurred at Rice Elementary School, where a family requested a gender support plan, a document outlining how the school would support a student's gender identity, like using preferred pronouns or names. But the school denied it because they said their child was not expressing gender dysphoric behavior. The parents claimed this denial was inconsistent with the district's guidelines, which they said encouraged schools to facilitate gender transitions without parental consent. The parents from both events claimed the school district's policies and actions violated their 14th Amendment substantive due process rights by interfering with their fundamental right to direct their children's care, custody, and upbringing. The district court, the initial claim was filed in May of 2023 to the U.S. District Court in Colorado. The district court granted the school district's motion to dismiss the case without prejudice, meaning the case could be refiled with fixes. The district court said that the children lacked standing to assert parental rights claims. Remember here, the children are suing through their parents. Also, the district court said that parents lacked standing for future injunctive relief because their children were no longer enrolled in the district. One child was in private school and others had graduated or moved on. The court went further, saying that the complaint did not adequately link the district's policies to specific harms. The parents did file a motion that amended their original case, but the district court still chose to dismiss the case. Upon appeal, the 10th Circuit upheld the dismissal, affirming the district court's decision. And now we get to the petition for certiorari we are dealing with today. The court has denied the petition for certiorari, letting the 10th Circuit's ruling stand. The case is currently closed at all levels, but the parents could theoretically refile since the case was dismissed without prejudice. All right, Kaimo, keep your mind open, do your own research, form your own opinion. Bye-bye.